Good morning, everyone. Thank you for joining us in this Reactive Chambers private client webinar. I'm William Moffett, and today Matthew Mills and I are going to be talking about claims and potential claims against personal representatives. We're going to look at two angles. We're going to look at claims and how to avoid them, and Matthew will be kicking us off with that. And then I'm going to be looking at the dialogue, really, between beneficiaries and personal representatives, especially where personal representatives are having to field sometimes very persistent requests for information or documents, which they're not sure should be handed over. So, Matthew, over to you to kick us off.
Thank you very much. Good morning, everyone. I'm Matt Mills, and I'm here to talk to you about claims against personal representatives. Now, for as long as there have been executors, there have been complaints that they've not been doing their jobs properly. But the difficulty for the law is that there's a fundamental tension in every case between two competing approaches. As Lord Chancellor Erskine put it over 200 years ago, the general rule as to the duty of an executor is founded upon two principles. First, in order not to deter persons from undertaking these offices, the court's extremely liberal. But second, care must be had to guard against abuse. And you can see that these pull in different directions. Now, to reflect these two principles, my talk today will have two parts. In the first half, I'll discuss when a personal representative will be liable for their own breach of duty, and when they'll be liable for the breaches of duty committed by their co-representatives. In the second half, I'll summarise the 10 ways that personal representatives can mitigate or avoid entirely this type of liability. And I'll divide that into two parts. Firstly, I'll talk about the proactive steps that PRs can take before making a decision. So that is renouncing, advertising, obtaining insurance, retaining a contingency fund, obtaining an indemnity from the beneficiaries, and seeking directions from the court. I'll finally talk about the reactive steps that personal representatives can take after a claim has been made against them. And that's relying on exclusion clauses, arguing that the claimants have concurred or acquiesced in what they're complaining about, relying on the law of limitation, and finally relying on Section 61 of the Trustee Act. Now, as you can see, there's quite a lot to be getting on with there, so let's get cracking with part one, claims against personal representatives. Now, because we're dealing with such an old area of law, the key word here is very old-fashioned, devastavit. That's a medieval Latin word, which literally translates as, he has laid waste. But what does that actually mean? Well, in a word, it means mismanagement. The most helpful way of thinking about it, though, is to consider it a breach of the duty of administration. And in practice, what that means is a failure to do one of three key things. Get in all of the estate assets promptly, pay all of the estate debts promptly, and then distribute the balance in accordance with the will or the rules of intestacy. Now, if someone's committed devastavit, it's likely the beneficiaries might also seek to remove them as personal representative. Now, I've covered this in a previous webinar, so I'm not going to talk about it again here. But if you'd like even more of my sumptuous voice, you can follow the link on the slide that you'll get after this session's over. So that's the basic idea. But who can claim it? Well, surprisingly, there is no reported decision which establishes precisely who can bring a claim for devastavit. However, it seems reasonably clear that a beneficiary or a creditor who've suffered loss can bring a claim. And in my view, if one of those people dies before they get around to issuing a claim, their personal representatives, i.e. the creditor's personal representative, should be able to issue a claim in their place. So those are the basics, but let's go into the detail a bit more. Traditionally, devastavit has been split into three different categories: maladministration, negligence, and misappropriation. But in reality, these categories blur into one. Now, if you want the full description of everything, chapter 52 of Williams, Mortimer and Sunnock's is where you should go. But what I'm going to do on these two slides is give you what are, in my view, the most important examples from the cases that are likely to apply in modern cases. So firstly, it's devastavit to distribute the estate to someone who's not actually a creditor or not actually a beneficiary. Makes sense. It's also devastavit to distribute the estate to beneficiaries before you've paid off all estate debts. Again, makes sense. We're getting more specific now. Paying inheritance tax out of the wrong part of the estate can be devastating. So in Rosenthal, IHT was said to come out of one of the particular assets, a property, but the personal representatives paid it out of the residuary fund. That was held to be devastating. Fourthly, failing to get in or convert estate assets promptly can amount to devastating. And fifthly, failing to pay interest-bearing or onerous loans promptly can also be devastating, because the longer you wait, the more they cost and the worse it is for the beneficiaries. On the flip side, PRs shouldn't jump the gun. If they call in high interest earning investments without any good reason, that can amount to devastating, because if they allow it to stay a bit longer, the estate can have more assets. Similarly, just delaying can be a problem. If personal representatives fail to pursue a claim on behalf of the estate, such that limitations now a problem, that can amount to devastating. The last 2 points relate to the personal representative themselves. It's devastating for a PR to use estate funds on themselves, for example, to pay for a holiday or support their own business, as in the Vise case. And personal representatives who purchase estate assets without the appropriate consent also commit devastating. So as you can see, there's quite a long list of things that can go wrong here. But there's a couple of examples that might be useful of things that are not devastating. It's not necessarily a breach to pay a debt of the estate that's limitation barred, as long as there's been no court determination on the point. And simply delaying in obtaining a grant of probate isn't by itself devastating. There needs to be some sort of loss. So that's what devastating is. But what remedies can the court give if the PR is found liable? In short, there are three main options: damages, an account of profits, and an order avoiding a transaction that the PR entered. For example, if the PR purportedly purchased estate assets, the court can set aside that transaction. In addition, don't forget that any beneficiary who says they should have received something may also be able to claim the assets from the wrongful recipient. For example, if the personal representative thought that John was a beneficiary and paid the estate to John, but he wasn't, the claimant may be able to sue John directly under the Reed-Diplock principles. Now, it's quite common for testators to appoint more than one personal representative to administer an estate. If one of those PRs commits devastating, then obviously they're liable for their own actions. But what about the other personal representative? Are they liable for their co-PR's actions? The general answer is no. One PR is not generally vicariously liable for the acts of another. The idea behind this rule is that the testator's misplaced confidence in one person shouldn't prejudice the other. And this is particularly true if the person doing the thing wrong is a professional PR and the other person is a lay personal representative. In those situations, the court's much more likely to accept that the lay personal representative wasn't negligent or didn't do anything wrong when they relied on the expert opinion and decision of a professional. But there is an important caveat. If one personal representative knows that the other is doing something wrong and they fail to take any steps to intervene, then both of them can be liable for devastating. That's because it's the duty of all executors to watch over and, if necessary, to correct the conduct of each other. So the short take home is, don't stand by and do nothing. So that's the doom and gloom part of my webinar. I'll now move on to the steps that the PRs can take to minimize or potentially avoid liability entirely. And we'll start with the proactive steps. These are the ones that PRs can take before they start making decisions or distributions. Option one: if you're advising someone who's named in the will as executor, but they've not yet taken any steps in relation to the estate, the simplest way to avoid all trouble is just to renounce. This will help the client avoid being liable for anything they haven't done and for anything that the people who ultimately become PRs might do. Now, obviously, this won't work in all cases. As I'm sure you're all aware, if someone's intermeddled in an estate they're not allowed to renounce. But it might be possible, so do bear this in mind. And if this is open to your client, renunciation must be done in writing, although it doesn't need to be done by deed. And if you go through all the right motions, it's very unlikely that your client could be sued for renouncing probate, because every personal representative needs to be given a choice before they've taken any steps of whether or not to act. But sometimes renouncing won't be open to your client. So this is where we move into the other options. Option 2 is to advertise the estate pursuant to Section 27 of the Trustee Act of 1925. In short, what this says is if a personal representative advertises their intention to make a distribution and nobody contacts them for 2 months, then the personal representative is free to make that distribution and can't be liable to anyone who later pops up. Now, if a PR wants to take advantage of this, they need to place an advert in up to 3 places: the Gazette, any local newspapers which are near to any land held by the estate, and in any other appropriate place. Now, in my view, it's always sensible just to put an advert in the local paper anyway, because that's where you're most likely to find friends, relatives, local creditors who might have some insight into the claims against the estate. If the personal representative follows these steps, then they're protected from claims not only by unknown creditors, but also by unknown beneficiaries who later pop up. Now, this sounds great, but please bear in mind there are 6 important caveats to this general principle here. Firstly, Section 27(2) confirms that this process does not protect the recipient of the money. For example, if the personal representative pays all the assets to John, the claimant can still sue John. And in practice, if the PR is a beneficiary, Section 27 doesn't really offer them that much protection because they can still be sued in their capacity as beneficiary. Secondly, to be protected, the personal representative needs to make sure that they comply strictly with all of the requirements of Section 27, because there are some old cases which suggest that if you don't do this, you don't do everything, you get no protection. Thirdly, the courts generally expect the adverts to be placed pretty promptly. In the Kay case, for example, Mr. Justice Romer suggested that a delay of 5 months after death was too long a wait. Fourthly, it's no defense for a personal representative to say, "I'm really sorry, I forgot." That's not allowed. Once they've received notice, they need to make sure they keep good records and deal with that claim. Fifthly, in some cases, personal representatives are expected to take account of later claims. If someone submits notice of their claim after the period in the advert has expired, but before distribution, let's say 2.5 months, then they should still consider that claim. And finally, and most importantly, it seems that Section 27 doesn't apply at all if the personal representative had no right to administer the estate. This might be relevant if someone takes letters of administration believing that they're the deceased's next of kin, but they actually find out that they're not. In that situation, they were never entitled to the grant. And in theory, Section 27 doesn't apply at all. So as you can see, Section 27 is a bit of a cheap and cheerful process. It can be useful in some cases, but don't see it as the cure to everything because there are quite a few caveats to how useful it can be. A third option is to obtain missing beneficiary insurance or unknown creditor insurance. These are policies which will pay out to the personal representative if someone emerges later down the line and claims to be a missing beneficiary or an unknown creditor. This option is particularly appropriate in cases involving small estates or where there's a relatively low risk of someone popping up at a later date. In those situations, the courts have said it's much more practical to go down this route rather than going through the rigmarole of a full application to court. However, the crucial point is that insurance is only ever as good as the terms of the policy. So a personal representative should make sure they read the terms in full very clearly, because they will be liable for any shortfall. So for any excesses or exclusions, or if the insurance is voided, it won't offer protection. So do bear that in mind if you're thinking about this option. A fourth option is for the personal representative to retain some of the estate assets as a contingency fund that can be used to pay any future claims. Now, in deciding whether to retain a contingency fund, personal representatives are expected to balance two competing interests. On the one hand, the interests of the known beneficiaries, who obviously want to be paid in full right now. On the other hand, you have to balance the risk that there are further claims that might emerge down the line. Personal representatives can't retain this money indefinitely. What they need to do is undertake a rational assessment of what sum should be retained and for how long, and this should be based on the evidence available. Now, do bear in mind as well, it's usually not appropriate to retain 100% of the money that's at risk, because after all, we're talking about risk and chances here rather than certainties. Also, if you do retain a contingency fund, the court will expect the PR to invest in an interest-bearing account. Otherwise, it will simply devalue with inflation over the years, and that's no good for the beneficiaries. Finally, the only way really to be 100% protected by a contingency fund is to get this authorized by the court. Simply making the decision yourself is helpful and can protect personal representatives to a certain extent, but it can't guarantee you protection. The fifth option is for the personal representative to seek a written indemnity from the beneficiaries who are about to inherit the estate. Now, in reality, a personal representative who mistakenly pays someone can try and recover those monies anyway, but having it in black and white, telling the beneficiaries in advance that they need to sign this document will smooth the process. Now, in deciding whether you're going to go down this route, you should consider the same things that I just talked about for contingency funds. So you need to balance the interests of the known beneficiaries and the risk of future claims. And again, it's usually not appropriate to require a 100% indemnity from beneficiaries because we're talking about chances, not certainties. But the crucial point about indemnities, the really important point, is make sure that you check beforehand that the people giving the indemnity will be good for the money. If the beneficiaries have a modest income, or if they have no substantial assets, then the indemnity might not be worth the paper it's written on. So the short point is do your homework, do your due diligence before you go down this route. Sixthly, if the personal representative doesn't feel confident relying on any of the methods I've just described, then they could consider making a claim under Part 64 of the CPR. Now, this has the advantage that if the PR puts all of the relevant information in front of the court and simply follows whatever order the court makes, they can't be personally liable. Now, the Part 64 procedure is quite useful because it's relatively flexible. For example, it's possible in particularly sensitive cases to make a confidentiality order. In particularly large cases, the court can make representation orders. And most importantly, the court can make re-Benjamin orders. These are orders which allow personal representatives to distribute the estate on a particular footing, for example, on the assumption that there are only 4 beneficiaries. However, don't be overzealous about rushing off to court in every case. The courts have emphasized that personal representatives should take all reasonable steps to resolve the issue out of court before making a claim. And if you don't do this, there is a risk that you could be penalized in costs, particularly if those costs are, in the view of the court, unnecessary. So do be careful here. So those were the proactive steps. I'll now talk about the reactive steps. These are the steps or things that the PR can say if a claim is later brought against them. The first thing that executors should do is check if there are any relevant exclusion clauses in the will. For example, clause 12 of the step standard provisions imposes various limits on a PR's liability. Now, the leading authority here is, of course, Armitage and Nurse. In that case, Lord Justice Millett held that clauses which purport to exclude a trustee's liability for fraud or unconscionable behaviour are simply unenforceable. And the same is probably true for clauses which would allow a PR to deliberately ignore the terms of the will or act in bad faith. But it's perfectly possible to have a clause which excludes liability for negligence. It's also worth bearing in mind that the solicitor who drafts the will can rely on the exclusion clauses even if they later become the personal representative. But the court will often construe exclusion clauses restrictively. So you've got to be very careful about the particular wording that you're seeking to rely on. Also, remember that exclusion clauses won't directly protect a personal representative from claims by third parties. It might give the personal representative an indemnity, but if the estate assets are already gone or the estate is relatively small, that indemnity might not be worth very much. If the personal representative can't rely on an exclusion clause, they may be able to rely on the beneficiary's prior concurrence or later acquiescence. Now, importantly, both of these defences apply whether or not the beneficiary benefited from the actions that they're complaining about. Now, obviously, the million-dollar question is, what is concurrence or acquiescence? Unfortunately, the answer isn't particularly clear-cut. As Lord Eldon put it over 200 years ago, we have to balance these two competing things. So if you look at the third line of the quote, how important it is on the one hand to secure the property of the beneficiary, and on the other, not to deter men from undertaking trusts. So again, we're balancing these two issues and basically trying to work out where the line should be. Fortunately, we can say two practical things. Firstly, delay by itself will only amount to acquiescence in very rare cases. For example, in the Sleeman case, there was 38 years of delay, and quite reasonably, the court said that amounted to acquiescence. But there aren't many other cases that have succeeded. And secondly, the court will only find concurrence or acquiescence if the beneficiaries knew all of the facts and the legal effect of what they were doing. In other words, if a PR wants to rely on this defense, they need to make sure that they gave the beneficiaries all of the information at the time and made sure they understood all of it before they made their decision. Sometimes personal representatives are faced with claims long after they've finished administering the estate. In those circumstances, they may be able to rely on the law of limitation. Now, this is quite an involved topic, and I'm quite quickly running out of time, so I will simply mention 6 key points. The first is that claims brought by people other than beneficiaries are subject to the usual limitation periods. For example, a standard negligence claim would be subject to a 6-year limitation period. Secondly, when someone issues a claim against the estate based on what the deceased did in their lifetime, time runs as usual. In particular, time does not stop when the deceased dies, and there is no pause for the period between death and a grant of probate. Time waits for no man. Thirdly, a creditor's claim in Devis Davit is likely to be barred after 6 years once the estate's been distributed. But for beneficiaries, it's likely to be 12 years after the estate's been distributed. Now, crucially, for residuary beneficiaries, the Court of Appeal has said that time starts to run only once the administration of the estate is complete. Now, it's not entirely clear if that also applies to specific legatees. In other words, people who are going to receive particular assets out of the estate while it's being administered. So there may be scope for personal representatives to argue in those cases, time runs a little earlier. But in any event, even though the period for the claim is 12 years, beneficiaries can only recover 6 years worth of interest. Finally, if all else fails, personal representatives can seek to rely on the court's discretion to excuse them from liability under Section 61 of the Trustee Act 1925. This allows the court to relieve a personal representative either in full or in part if 3 conditions are met. The PR acted honestly, they acted reasonably, and they ought fairly to be excused. Now, the personal representative bears the burden of proving all 3 of these points here. And to do this, the court will expect the personal representative to provide a full and frank account of all of their actions leading up to the complained about events. So make sure you give everything to the court if you want to rely on this defense. Now, each case turns on its own facts because this is such a wide discretion here, hence the phrase ought fairly to be excused. But we can get 5 useful principles from the cases. Firstly, the question of honesty will be assessed objectively. In other words, the court will ask itself, what would a hypothetical honest person have done, rather than what did you think the right answer was? Secondly, acting reasonably generally means acting as an ordinary man of business would act with their own property. Thirdly, as I've been mentioning throughout, the court will balance these two principles that are in tension. On the one hand, they'll consider the effect of a judgment against the personal representative. On the other hand, the court will consider the effect of granting relief on the beneficiaries. Fourthly, just because the personal representative took legal advice at the time does not mean they'll get off scot-free. But obviously, the bigger the issue, the more likely personal representatives are to need to take legal advice, and failing to do so on important matters is usually quite a big problem. Finally, the court will take into account whether the personal representative is a professional or not, and if they are, how much they're being paid. So the short point is, professional personal representatives need to be very cautious here, because they're often held to a slightly higher standard than lay representatives. And there you have it. We've gone all the way from medieval Latin words to modern professional PRs. We've covered a lot of ground there, and if you have any questions, please do type them in the Q&A box at the bottom of your screen, and I'll do my best to answer them at the end. But for now, it's what you've been waiting for. It's our headline act. It's William Moffett.
Thank you for that extremely comprehensive review, condensing a lot of law. I'm going to continue Matthew's theme, which is to look at matters from the point of view of the personal representative, in particular with the professional PR in mind. Although, of course, the principles I'll be talking about are equally applicable if we're acting for beneficiaries. And I'm going to be looking at what is often the greatest source of tension during the course of the administration. Beneficiaries asking questions, requesting information, requesting documents, and the personal representatives being in a position where it's not clear whether they should be giving that information or providing those documents. I've asked the rhetorical question, must I be at their beck and call? The short answer is no. However, I appreciate that personal representatives who are being put through their paces by particularly persistent and inquisitive beneficiaries may not feel that way at all times. I'll break this short talk into three parts. I'll look at core principles briefly. Then I'm going to look at a few cases which I think illustrate a suitable breadth of points that arise in this area. And then I'm going to try and draw some themes from them. Starting with the core principles. Once the PR is seized of the estate and its assets, it's obviously good practice to notify the legatees of their legacies and to provide them with information at the get-go. But strictly speaking, that's not a duty. In contrast with the law of trusts, of which there's a considerable overlap, as you'll see, it's strictly, there is no, if you like, upfront duty to inform legatees. And that can and has, in a number of cases, operated unfairly towards legatees, especially where their gifts are conditional. And that is the principle in Reed Lewis. And it's actually the facts of Reed Lewis were an example of how unfairly this can operate. Mrs. Lewis left her estate under the care of her executor, one of her sons. She left property to another of her sons who lived in Patagonia, in a Welsh-speaking enclave of Argentina, on condition that he come home to claim his gift. He didn't know of this condition because his brother didn't tell him. His brother benefited by taking a gift over on the lapse of the gift to the intended son. And that was not held to be any breach of duty by the executor. There was no duty to contact the beneficiary and tell them of the condition that he had to comply with. Equally, there's no general duty of consultation, although in some cases it's going to be proven that beneficiaries are consulted or canvassed on their views of a particularly sensitive decision, perhaps. There's no duty of that. And indeed, in respect of executors holding land, Section 11 of Tilatra is expressly disapplied by Section 18. So there's no duty of consultation. It's well known that PRs are under a duty to keep records and to be ready with an inventory and account of the estate, and that's a statutory obligation, as we well know. Enforcing that obligation is by application to the principal registry by summons. That's governed by the non-contentious probate rules. Note here that a request for an account can also be made by a creditor of the estate or someone who credibly puts them forward as a creditor of the estate. The essence of the question of provision of accounts and other documents and information to those requesting it is that it's a discretionary approach. It's subject to the court's supervisory jurisdiction, and that's been in parallel with the law of trusts and the decision in Schmidt and Rosewood Trust, as we well know. Nonetheless, you will find, no doubt, the persistent belief or argument that the beneficiary is entitled to documents and information as of right. As they might see it, it is after all their money that the PRs are spending in collating that information or obtaining advice, whatever it is that the beneficiary wants to see. And so the beneficiary logically says, well, it's my money, you've spent acquiring this, I want to see it. Nonetheless, there are significant reasons for this discretionary approach. And one of the main ones, of course, is the Londonderry principle. The principle that beneficiaries should not have a window into the decision-making processes of personal representatives and trustees, which should remain confidential. I'm going to turn now to some case studies, necessarily a whistle-stop tour across these 5 cases. I'll give you a very brief synopsis of each and the decisions in each. Starting, I should say there are a variety of wins for beneficiaries, wins for personal representatives refusing disclosure, and at least one score draw. I'm going to start actually with the score draw, which is Hedgley and Thompson, which are a benchmark decision on the duty to account that we should all be aware of. The background was that there were 2 family trusts created in 1960, one of real property and a very small share portfolio with the Hedgley Trust, and a second family trust, which was shares in the family business, known as the Children's Trust. In respect to the Children's Trust, the shares have been liquidated at a loss in the early 1990s. No tax returns in that trust have been filed since 96. And the defendant trustee have regarded everything as being done and dusted and wound up in the mid-90s, and therefore professed perplexity that he was being pursued for information some 2 decades later. And indeed, his defense was very robust. Long delay, it's pointless asking me any more questions because I'm not going to be able to remember it anyway. If I haven't kept records, I haven't kept records. What is the point of an order for an account? He also pointed out that any claims that were arising from the account that he might give were likely to be time-barred anyway, such as a breach of trust. He also at one point tried to say, well, he had little actual day-to-day involvement with the trust anyway. That was all done by the bookkeeper, a lady called Doris. Needless to say, the attempt to blame Doris was not an attractive line of defence when it came to a final hearing. The decision is that of the former Chief Master Marsh. He rejected the submission that a right to account was as of right. It was a discretion, it is a discretion, albeit the refusal to an account is something that will be exercised only very sparingly. It's a vital aspect of the accountability of trustees, which sits alongside their duty of record keeping. It is the tool by which beneficiaries can hold personal representatives and trustees to account. There is no limitation period for seeking an account. It doesn't fall within any of the categories under the limitation of 1980. Laches would apply, the equitable doctrine of Laches, but given that it is a discretion anyway, separate consideration of Laches is unlikely to add much. If there's been a long delay, that would probably militate in favour of exercising the discretion for refusal of accounts. They don't have to be in any particular form, and the authorities are clear to distinguish between the accounts that PRs are to provide from financial statements for businesses. This is not an accountancy exercise. It is something different. It has core irreducible information that you need. You have to show that from period to period, there's no particular fixed period, how the trust assets have been dealt with, including what distributions and disposals have taken place. And you need to put the beneficiary in the following position. They need to be able to read the trust accounts. They must be in a position to assess whether the trust assets conform with the trust instrument, and that the class of assets held is appropriate for the trust. Necessarily, the style and content of accounts is going to vary from situation to situation. The decision in that case, in respect of the Henchley Trust, that's the trust of the property, there was a valid criticism that no accounts had ever been produced for this trust. But the main asset, which was visible in bricks and mortar, was still there. And the pointlessness of ordering an account was overwhelming in that respect. So there was no order for accounts, but there was an order made for the accounts in the Children's Trust. The last accounts that had been produced, the Chief Master regarded as troubling, dating back to the early 90s. And it was true that claims that may arise could be time barred, but you didn't know until you got the information. You wouldn't know the shape of the claim, so you couldn't say that it was necessarily time barred. But even if they were, knowledge was an end in itself. The beneficiaries would at least know what had happened, and the grandchildren of the sector would know why, in fact, they still received nothing. So that would be an explanation which had a value in itself, whether or not any consequential action could be taken in any event. Turn to the second of the cases I want to introduce to you, which is Ball against Ball. It's another family business and family trust. It involved the three children of the Ball family. Two were directors of a family business, which was a department store, Rose Department Stores in Bude in Cornwall. The third child, Jonathan, who was the claimant in this claim, was not a director of the family business, and his exclusion from it, or his lack of participation in it, was partly what informed this litigation. Father's estate had included some shareholding in the family business and an interest in the store premises themselves. His will created a life interest in favour of his wife, the party's mother, and the residue to the three children. They were executors and trustees. Mother died some time ago in 1978, and mother didn't die until 2016. So you're looking at a very long life interest trust over a period of 38 years. And truth be told, nothing much had happened. The trustees, including the claimant Jonathan himself, hadn't really done much. They hadn't actively participated in keeping accounts. His suspicions were that what had happened had favoured the family business in which his siblings were interested, but he was not. So it was a process, a pattern of reinvestment in the business. And indeed, mother had waived her right to dividends in a letter in which she signed off money as a good servant, but an evil master. Have some wisdom that many litigants could take on board. The waiver had actually been co-signed by the trustees themselves. A long line of pre-action correspondence. The defendant solicitors had sent information in the form of a letter, 5 closely typed pages with various information about the estate and about the business in which these shares that they held apply. So he replied saying, I want more than that. Jonathan said that he wanted statutory books, 4 minutes, a lot of information over a 40-year period relating to the business. The decision, which is again a decision of Chief Master Marsh, drawing from his previous decision in Henchley. First he said, well, the fact that the claimant himself is a beneficiary and a trustee isn't an impediment. So he was in a position to have properly ordered the accounts as they went along. The fact that he hadn't done so wasn't a bar to him as a beneficiary seeking that relief or a trustee seeking from another trustee that relief. He needed to, what he didn't need to show was there'd been any breach of trust by his siblings, other than the failure to provide accounts themselves. So that he didn't need to show that there was any wrongdoing in order to set up his inquiry into the past dealings. There's quite an interesting passage that really sets out, in very simple terms, what accounts should comprise. Again, distinguishing them from business accounts, really 4 main things, which is to state what the assets were, what has been done with them, where they are now, and what distributions have been made. Question arises, how much narrative do you need to go into when you produce accounts? And it is possible that narrative explanations required, as the Chief Master said, a set form in which trustees are required to account. At heart, the obligation is to inform, where explanation is required to explain. So the obligation is to inform. If you think an explanation is required, if it's not self-evident from the case you produced, you need to provide it. On the facts of that particular case, the letter that had been sent in March 18 was enough. It wasn't in any particular formal document, but it provided all the information that you could sensibly expect. So the claim was dismissed. Shakespeare and Acklin is the next case that I'd like to introduce to you, which is, as you will probably know, is a case about a letter of wishes and whether that had to be disclosed. It concerned a family discretionary trust. The trustees had refused the letter of wishes to the claimants on the basis that it was confidential. The general temperature was that the claimants were seeking to show that the, as they put it, that the trustees displayed a wrong-headed and unfair tight-fistedness in relation to disclosure, and that they had shut their minds to giving the disclosure that they ought to. The decision is a very comprehensive one of Mr. Justice Briggs's memoirs, and held that the Londonderry principle can apply to letters of wishes. That is, that the confidentiality of the decision-making process the trustees go through should be preserved, and the letter of wishes was part of that process. He said that it seems to me that disclosure sought by a beneficiary for the purpose of evaluating his or her prospective entitlement may too easily, once obtained, be used for the purpose of challenging the subsequent exercise by the trustees of their dispositive discretion on grounds of rationality. That, you might say, is an overprotective approach to take towards trustees and personal representatives, because, of course, the very purpose of disclosure, part of it is the accountability of trustees and PRs. What the judge was keen to stress was that this was not a blanket rule that he was imposing, that letters of wishes were always confidential and therefore should always be refused, or could always legitimately be refused from disclosure. There's no fixed rules about it. It's an exercise of discretion. It's an objective assessment of what the consequences would be if you did disclose it, not an inquiry into the subjective purposes behind the request. And the overarching duty is to do what's in the best interests of the beneficiaries as a whole and the efficient administration of the trust as a whole. There are various versatile approaches one can take where documents are sensitive. You can redact them. The recipient can give, or their lawyers can give undertakings as to who will read them, who will use them, and how far they'll be disseminated. You can hand them over to a professional third party for review to decide whether they should be disclosed or not, or in what part. And one of the approaches that was taken in Breakspear was that the letter of wishes was put in a sealed envelope for the judge to decide whether he alone should read it, which he did in that case. So there are various flexible tools that we can use in difficult situations. The outcome was that the trustees were justified in their refusal. Their decision to protect the confidentiality of the decision-making process was justified. Although in that case, the outcome was that the letter of wishes was disclosed. Why? Because the trustees had revealed that in fact they'd be coming back to court shortly to ask the court to sanction a particular distribution among the beneficiaries, in the course of which their decision-making process, if you like, would be an issue. In fact, the beneficiaries got their way, albeit in an indirect route. The next case I want to draw your attention is a case called Lewis and Tamplin, the decision of His Honour Judge Matthews in 2018. It was a trust, a small family trust of a very modest family farm, less than 13 acres. It happened to be in a very favourable spot near a junction of the M4, and suddenly became extremely valuable, worth over £10 million. The beneficiaries, who were the later generations of the settlers, Mr. and Mrs. Tamplin, sought various documents as to what had been done to maximise the benefit of the development value of the land. The professional advice that had been sought, planning consultant, surveyors, council, the CFAs under which these professionals were acting, they wanted to see those, and they wanted to know what use of the land had been made in the meantime, to protect it, to the grazing rights over it. There was very steadfast resistance to disclosure, which seemed to originate from family tensions. And indeed, for a long time, the trustees, who were family members and beneficiaries themselves, have refused to recognise a particular branch of the family as being beneficiaries at all, something which they later had to come to terms with. They couldn't come to terms with providing them all the information about many years' worth of administration of this family trust. The judge held that disclosure, as we know, is an exercise of discretion, not a matter of right. The trustees had sought to argue that under the Londonderry principle, which protected the decision-making, the very decision not to give disclosure was also one that should be protected, if you like, in a rather circular way. The judge rejected that the role of the court in these cases is not to review the decision not to give disclosure. It is to exercise the discretion for itself. What was interesting in Lewis and Tamplin was that the beneficiaries all had fixed shares. The branches of the family in the issue all had particular shares in this trust. And the decision does focus at considerable length on the difference between a discretionary beneficiary and a person who has a fixed interest, vested interest. The latter will be in a much stronger position, closer, if you like, to the proprietary right that sometimes is still argued by beneficiaries and used to be the understanding of what the nature of the beneficiary's right to claim the documents. So a fixed interest beneficiary, rather than discretionary beneficiary, will be a very much stronger position. And his review of the judge's review of Schmidt is to find an implication in that decision that a beneficiary with a fixed transmission of interest would normally obtain the assistance of the court. So it's very important to consider the nature of the beneficial holding when one's answering a request for information. If you're refusing a fixed interest beneficiary a right to see documents or a right to information, your reasons are likely need to be exceptional. And an example was given from a New Zealand case called Urcheg against Urcheg, where the assets of the trust in that case included business interests which operated in conflict to one of the beneficiary's own businesses. And indeed, the beneficiary had threatened to deliberately use the information that he would get on disclosure as a sort of act of sabotage. He would publish it. He would publish commercially sensitive information as a sort of spoiling intent. And that might justify a refusal, for example. But in this case, in Lewis and Tamplin, the beneficiaries were asking for the information for precisely the right reasons, which is the whole to account. The Londonderry principle was also considered, and the judge considered whether it applied equally to administrative functions of trustees and PRs as it did to dispositive powers, i.e. powers in which you decide who gets the money. And he considered, and he found authority in Shakespeare and Acklin, that it would only apply to dispositive powers. I should say that's a controversial finding, potentially. It's certainly contradicted by the authors of Lewin, who refer to a pension case from Wilson. And after all, a lot of administrative decisions can be highly controversial. So query whether that will come to be tested in another case. But there it is. Londonderry only applies to dispositive powers, not the exercise of administrative powers, according to Lewis and Tamplin. There was a warning for beneficiaries generally, though, about pushing too far and what they want the information for. You can seek information about the trust, about its assets, and the trustee's stewardship of it and of them, but it's not a means of trying to get parity with the trustees, to sit on their shoulder, to see all the information they have from moment to moment, as if to participate in the decision-making process. That isn't what a request for information should allow you to do, nor is it what the judge called old-fashioned interrogatories. So why are you doing this? Why are you doing this? All teed up towards a potential claim against the PRs and trustees, essentially trying to cross-examine them in correspondence, trying to convict themselves out of their own mouths, as the judge put it. In this case, thankfully, I say thankfully because I acted for the beneficiaries, they hadn't overstepped the mark. Disclosure was ordered. And in that case, the trustees were found to have acted so unreasonably in their refusal that they were denied their indemnity out of the trust fund for the costs of the litigation, and were made to pay them personally and on the indemnity basis, or on the basis that the refusal had been indefensible. But that's extreme facts, and we'll look next at Blades and Isaacs, where you see a more generous approach to the cost of litigation incurred by trustees. Blades and Isaac is another case about a small family trust. Claimants was one of two sisters who were beneficiaries. It was a discretionary will trust created by their late mother. There was a history of difficult family relations. There was a letter of wishes in which the mother had expressed the wish that the older sister, the non-party, could be joined as a beneficiary and receive 5% of the estate, which is something that the trustees, executive trustees had done. The executive trustees were professionals from the firm who had drawn up the will in the first place. The claimant wanted an inventory of the estate, trust accounts, wanted to see the letter of wishes. And this request was refused, a blanket refusal of all the information that was sought, on the basis of the defendant, the professional executive trustee's honest belief that it would cause family harm, that there was a distinction and large financial difference between what had been given from one sister to the other, and it was best that they didn't know this, or that this wasn't out in the public. It would do them no good. What they did was one of the flexible routes I mentioned earlier, was they just decided to disclose, to hand it over to a professional third party, Chancery Council, to advise on whether they should give disclosure. Surprisingly, the Council endorsed the decision not to provide any of that information. By the time it reached court, the writing was on the wall, and they changed counsel. Subsequent counsel, which I just said was from Reactive Chambers, said that no, that's not right. You need disclosure here. And it was an exercise in limitation, which he carried off very successfully, I should say, because the hearing then became a cost argument. The claimant had won. Everything had been handed over that she wanted shortly before it came to court. And the court had to consider what the cost position was. The general cost that in adversarial litigation costs for the event, considered against the general rule that trustees will have an indemnity, as is enshrined in the CPR, and only lose that indemnity if their costs haven't been properly incurred. And it's a case in which you see just how protected, in fact, the cost jurisdiction can be towards PRs and trustees. The court referred to the Master of the Rolls words in Hugh and Scarr from 1875. Mere neglect wasn't enough to make an honest executive pay costs. It was an onerous and thankless task as it was. So making a mistake, getting it wrong, essentially, doesn't mean you have to pay the costs. You need something like gross neglect or wholly indefensible refusal to provide accounts. And in this case, the court found that the defence, although they got it wrong, they acted in good faith. And indeed, they genuinely held the view that it would be nothing for family relations to disclose the information. And they had, after all, taken advice of counsel and followed it, albeit that advice was wrong too. They would also have been somewhat hasty in issuing, it was said, because the defendants had, in correspondence, said, well, if we need to, we'll ask the court for a direction on this, but the claimant had gone ahead and issued. It does come with a warning for beneficiaries, that decision, because the feeling was, as the judge put it, the master put it, the claimant may have lost sight of the important point that the discretionary trust was imposed on the estate of the testatrix by the express desire of the testatrix herself. She did not wish either of them, her daughters, to play any part in the administration of either the estate or the trust which she created. An important reminder, of course, that PRs and trustees are there for a reason. They're there because the beneficiaries are not meant to conduct the administration of the trust or the administration of the estate. And there is good cause for that. The So the court in that case exercised its discretion to make an order for costs. And of course, the defendants would be indemnified out of the will trust fund. He held that even if he had made an order that the defendants paid the claimant's costs, the indemnity would still have applied. So in either outcome, the claimant would end up paying her own costs and those of the defendants, even though she was right and even though they were wrong, which she would later say was a somewhat harsh outcome. But there we are, protective of the PRs. I'm going to round up in the time remaining with the themes I suggest we can extract from these cases. Clearly, there's an emphasis on the discretionary nature of this regime. It makes cases more difficult to predict. They're going to be very fact sensitive. It is said that there is a tendency to favour ordering disclosure, and I can see why some commentators think that trend exists. And it is, at the end of the day, not difficult for even beneficiaries who are troublemaking to dress up requests for information in a way that appears credible, but is difficult for PRs or trustees to resist legitimately. I picked out 11 themes which I'll rattle through. You've got to exercise the discretion in the best interest of the beneficiaries and the administration of the trust. It's part of furthering the accountability of the personal representatives. You shouldn't exercise it for self-preservation. So if you suspect that the information requested of you is there to tee up a claim against you for some breach of trust or breach of duty, that isn't a reason, obviously, to withhold that if it's otherwise justified. When it comes to court, it's not a matter for review of the decision to refuse disclosure. The court will exercise its own discretion in you. Refusing accounts, inventory and account, is rarely going to be justified, other than perhaps very, very stale cases. There's no time limit to seeking an account, but excessive delay might justify refusal, as I said. The barring of any consequential claims may be a factor, but knowledge can be an end in itself. That is not an absolute bar. Accounts need take no particular form as long as the core information is there. You have to consider the nature of the beneficial interest of the beneficiary who seeks the information. Is it a fixed interest or discretionary interest? Is it a remote interest? The more remote, obviously, the weaker the claim for disclosure. Is it a capital beneficiary or an income beneficiary? The former might not be entitled to see accounts relating to the use of income. Invoking Londonderry principle is going to be more difficult in the case of an administrative power, as opposed to a dispositive one, and indeed on the strength of Lewis and Franklin, even impossible to do so, arguably. It's not a means of quizzing the PRs or trustees. There's a cost regime that's protected the PRs acting in good faith. The cost of preparing the accounts themselves is usually borne by the estate, unless it's a bespoke request, in which case the beneficiary can be asked to pay it. I've listed there some possible reasons for refusal. Delay, stale claims, but not always. Pointlessness to the relief, again, but not always. The remoter the interest, the less likely a pecuniary legatee who's already been offered their payment would have little cause to see accounts for the estate, we would think. Protecting confidentiality, welfare of beneficiaries as a whole, commercial sensitivity, and you could say that sufficient information has already been given, such as it is. Note the creative solutions that we talked about earlier, the undertakings, the sealed envelopes, the professional third-party intervention. Finally, these aren't the only means that beneficiaries can seek information. What I haven't spoken about is pre-action disclosure under the CPR 3116, nor data subject access requests, which were seen famously in the Dawson-Damer litigation. We've run out of time, so I'm going to wind up there.
There have been a couple of questions that have come in for me, which I'll briefly address. Anonymous has said, how would we do due diligence to check the beneficiary is good for the money re an indemnity? Off the top of my head, I can think of a couple of practical steps. Firstly, you can ask the personal representative and or the deceased's family to see if they know anything about this person, their jobs, their assets. You could do a land registry search to see if they own any property, and you could just ask them, You can explain honestly the difficulty that the personal representative faces and why they're asking for this indemnity, and try to make a cooperative approach the right way. Michelle has then asked me, what amounts to intermeddling? Can executors look into assets first? In a nutshell, intermeddling means taking steps that a PR would do in the administration of the estate. And I'd recommend you be cautious about doing too much here. There's an old case called Robbins from 1601, which says the slightest intermeddling with goods is enough. In that case, they gave an example of taking a Bible or a bedstead of small value. Now, you could make two arguments in your favor. You can say, firstly, it's better if you can do this without handling any of the goods at all, if you're literally just looking, so you're not touching. And secondly, there is an exception that acts of humanity or necessity don't amount to intermeddling. For example, if you put a lock on the deceased's property to stop it being robbed, or if you do urgent repairs, that's not intermeddling. So those are the kind of principles you could have in mind when taking some steps, but you've got to be very, very careful here, because slight steps can amount to intermeddling. Anonymous has asked me, does the obligation to meet liabilities before distributions apply to specific legacies? Now, I assume you're talking about a solvent estate here, and if so, the answer is in part 2 of Schedule 1 of the Administration of Estates Act 1925, which basically sets out the order in which particular assets must be used to pay estate debts. Property which will be specifically bequeathed is in that list, but it's sixth. So what that tells you is there are lots of other things that will be used first, but specifically bequeathed property can still be used. And that's because the general rule, obviously, is that debts are paid before legacies. Anonymous has asked me, where a will allows a lay executor to be paid, how do you assess what's reasonable remuneration? Now, how long is a piece of string? It's always very difficult to define reasonable, but a helpful case for you is probably Pullen and Wilson from 2014. In that case, His Honour Judge Hodge QC was discussing the statutory right to reasonable remuneration under the Trustee Act. And he basically said there's no strict formulae for what is reasonable. It's an evaluative exercise that takes into account the nature and the value of the services you've provided and the proportionality of what you've done and what it's cost to the value of the estate. But he did allow expert evidence of market rates to be submitted so that you can use a comparison and say we're cheaper or whatever compared to somebody else. So that's probably the best guidance you've got, but it's really difficult to find an exact figure for what is reasonable in any case. Thank you very much for joining us, and goodbye.